Um, um, Good morning, everyone. We are going to continue with the presentation of Professor Loder, Mr. Arno, and afterwards we're going to have a panel session on privacy law and legal assets.
Good morning, everyone. I'm very sorry that I'm not in Stockholm right now. I never been to Sweden, and I really looked forward at being there. But as you might have heard, I did something very stupid that normal people never do. For me, it wasn't the first time. Back in 2002, I was very proud. I just started teaching e-commerce law. I was very proud to travel with EasyJet without a paper ticket. And I just had to go to the airport with my passport. And when I arrived there, I showed them my passport and they said, your plane had just left from Edinburgh, because apparently they booked my ticket for the day before. But then it wasn't my fault. The organization over there made a mistake. So now I did it myself, and I hope I never do it again. So again, I'm very sorry that I was not able to get to Stockholm. I want to tell a few things about the GDPR. Not too much, because I know it can be very annoying and not very exciting to look at this talking head. One thing I want to stress is about the success of the GDPR. There's a lot of discussion about whether or not the GDPR is a success. I think in one way it isn't, because it's a too blunt instrument for regulating data protection rights, because the Facebooks and Googles of the world have to comply with the same norms as, for instance, local transport organizations, or the butcher next door, or schools, or whatever. So in that sense, I don't think it's very successful. But, and there are a lot of misunderstandings also with the smaller organization about what they should and shouldn't do. I will give an example of it shortly. But what I think is very good of the GDPR is that it made people aware. And that already started before the GDPR was enacted, because of the high fines. People were afraid of getting fined for a large sum of money. And that's why they started thinking about their information processing activities related to personal data. I think that's a very good thing, that made people aware, made people think about these things. And that basically also boils down to the Article 5 of the GDPR that I will address shortly. And it can also contribute to maturing the way in which we as a society and as companies and governments process personal data. And some people even say that there might come one day that we no longer need a GDPR, because everyone knows how to deal with personal data. But I don't think it will be very soon. What I want to address in this short presentation is to start with an anecdote on passenger lists, then say a little bit about the difference between privacy and data protection, address the concept New Privacy Act, in which I will say that GDPR isn't a privacy act and the content isn't really new. Then the principles of GDPR, security of processing, privacy impact assessment, and data protection by default and design. If I take too much time, please interrupt me. I won't be offended if you do. So just stop me if it gets boring or takes too much time. The first thing I want to stress is the difference between privacy and data protection. Privacy is it's both regulated in the Charter of the European Union, Article 7 and Article 8, and the right to privacy is best typified as the right to be let alone. And it's formulated in the article of the Charter as everyone has the right to respect for his or her private and family life, home and communications. Then there is the right to data protection, which is about an individual's right to control, edit, manage and delete information about themselves and decide when, how and to what extent information is communicated to others. And this data protection right has a link to privacy because it's often called informational privacy, so that's one part of privacy. But data protection can also apply to personal data to which the data subject no longer have a reasonable expectation of privacy. For instance, if you post some information on the World Wide Web, on a social media platform, for instance, you lost your reasonable expectation of privacy. If you share stories about this meeting, or you're walking through Stockholm, or some pictures when you were on the beach in Barcelona or whatever, this information no longer has something to do with privacy if you've put it on the World Wide Web. You lost your reasonable expectation of privacy, but the data protection rules still apply. If someone wants to do something with those data, collect them, analyze them, etc., they at least need a purpose to process those data to begin with. So the data protection rules in these circumstances still apply. It's also relevant in the case of, for instance, medical data and special categories of data, because there's a general prohibition to process those data because they're special categories. But if you post this information on the internet, the prohibition no longer applies. So then it's possible to process those data. One thing that strikes me very much is the fact that the word privacy isn't mentioned a single time in the GDPR. I'm not really telling the truth, because it's mentioned a single time, namely in the footnotes to the e-privacy directive, but further on it's never mentioned, and it has something strange. There's something strange connected to the fact that it isn't mentioned, because it was mentioned before, but there has been some sort of cleaning operation where they swiped out all the references to privacy. And as a consequence, very common terms you're probably all aware of, like privacy impact assessment, privacy by default, and privacy by design, are now called data protection impact assessment, data protection by default, and data protection by design. So it's in a very extreme way they got rid of all the references to privacy. It looks like it resembles to me a sort of 1984 operation to no longer have reference to privacy, so we can't use it. I don't know, but it's quite strange thing that it happened. Also, if you look at the governments or people in practice, they of course still call it privacy impact assessment or privacy by default, etc., because they are used to this term for already like 10, 20 or 30 years. The next point I want to address is that there's often reference to the new Privacy Act. Well, I already addressed the fact that GDPR isn't really a privacy act, but it's also not really new. And then I sort of smoothly move into my next point, the principles of the GDPR. That's Article 5. These principles were there already in the 1980s. I have a slide for myself here that you can't see. I'm sorry about it. So you have the Organization of Economic and I'm not sure where the C stands for, economic and some C, cultural maybe, development. They defined the fair information principles back in the late 1970s or early 1980s, and it also became part of a treaty of the Council of Europe, and they were working on those fair information practices. They're actually called not principles, practices, back in the 1970s, also in the Northern Americas. And these principles, so 40 years old, are the core of the GDPR, because they're mentioned in Article 5, which is the core of the GDPR. GDPR actually has 3 pillars. One is that the controller has to comply and the processor has to comply with all kinds of norms, then the rights of the data subjects, and that there is a supervising authority. But the core of the for the data controllers, and often if I address people who process personal data, I tell them, well, look at Article 5, consider those principles. There are 6 principles. Think about your organization, and once you are able to make a good story of what you do with these principles, you're almost finished with being compliance with the GDPR. And that's a novelty in the GDPR actually, because these principles used there to be also in the prior legislation, Data Protection Directive, but under the Data Protection Directive, the controller had to ensure that the principles were complied with, and now under the GDPR, the controller shall be responsible for and be able to demonstrate compliance with paragraph 1, and that's the central article of the GDPR actually, and defines the basic principles, and that's also a difference. You had to notify the authority before the GDPR became into force of the fact that you were processing personal data. Under the GDPR, you no longer have to notify, but you should be able, if the authority comes or if a data subject asks for it, you should be able to demonstrate that you are operating in compliance with those principles. And those principles are, for instance, to begin with, you have to process lawfully, fairly, and transparent. Transparent is a new principle in the GDPR. As such, it wasn't there in the data protection directive. Lawfulness means that you should have a ground for processing. Fairness links in, some people say, to ethics, so that you have to look also beyond what's necessary based on the law. And transparency is about being clear about what you're doing, in particular in connection with the data subjects. Then there's the purpose limitation principle. You have to specify a purpose for the processing. This is also a very central thing you have to do when you're processing personal data. You have to think about, why am I processing these personal data? And actually, to me, and often this is overlooked, but people forget most of the times, why are they processing in the first place? So they have those data and they think we're going to process them, and then they're trying to make up a purpose for the processing. But what they actually should do before thinking about specifying a purpose is, why am I processing these data? Does it make any sense to process these data? And sometimes it really doesn't make sense to process data, and then why you should then process those data. So, but purpose specification is very important. Then you have minimization, data minimization, and I have an interesting example in that respect from my own university, where they process the data of the coffee we take from the machine on a personal level. So each coffee you take, the type of coffee and the time you take it is being recorded for 7 years. And that's an example that doesn't, if you use common sense, and that's often the case with data protection law, if you use common sense, then you also, without the legal framework, you can come up with solutions that are in compliance with the legal framework, because of course using for 7 years those data isn't what you would call data minimization. Then another principle is accurate. The data should be accurate, and I actually was thinking about, but I didn't find time for it yet, to start a class action case, so a court case with a group of people against data brokers and people doing advertisements, because they are very annoying for one, but also I think that the profiles they have aren't always very accurate in the data they're using. So that could be an interesting ground to file a lawsuit against data brokers and social media platforms, etc. And then the other two principles, storage limitations. So you have to delete data if you no longer need them. So that's another important. And the last one is also new, and I will come back to it when I discuss Article 32 briefly. It's integrity and confidentiality, and that's about cybersecurity basically, and that's the concept of operating in an integer and confidential matter is of course not new, but it's new as a principle. It wasn't defined as a principle in the data protection directive, and it's important that it's a principle in the GDPR, because it means that the controller has to demonstrate compliance with the integrity and confidentiality principle. And this nicely brings us to the Article 32 I wanted to discuss next. It's about security of processing. And then I move to my it's a very interesting website, GDPR hyphen. Oh, I can I can put it in my in my text thing. I should do it correctly. Oh my, yeah, there you go. So this URL, very nice URL. I can type it again because it goes away very quickly. Here this is article 25 apparently, but you can see all articles neatly organized at this website. So it's a very interesting website. And I'm now moving to article 32. If here's article 32. So article 32 is about security of processing. A basic thing is that you have to take into the account the state of the art if you think about security of processing, about security measures that will all appeal to you and make sense, that you should use outdated patches or outdated software, etc. So you should take into account the state of the art. Also the cost of implementation. You should relate what you have to put into to security money-wise in what it brings you or the data subjects in the end. Then the nature, scope, and context of processing, as well as the risks. So you have to take the risk into account. And what you have to do based on these concepts. The risks refers to the likelihood and severity for the rights and freedoms of natural persons. So it depends on the data you're processing and how many data, etc. The controller and the processor shall implement appropriate technical and organizational measures to ensure a level of security appropriate to the risk, including, and then there are some examples, pseudonymization, encryption of personal data. If you encrypt personal data, then even in case of loss, often people can't access the actual personal data, depending on the level of encryption, of course. And pseudonymization is another measure that can help you realize security. If you, for instance, have a number in your data processing activities and link that to the personal data in an offline database, for instance, then if the database is attacked, then they only have the numbers and don't know who it relate to, basically. Then you have to, that will appeal to all of you very much, of course, the ability to ensure the ongoing CIA, so the confidentiality, integrity, availability, and the resilience of your system. So if something goes wrong, you should be able to back up and these kind of things. That's actually mentioned explicitly, the backup, so the ability to restore. And the process, you also have a process for regularly testing, so pen testing, and so test your security, not only describe that it's work, but also practically test your security. So that's what you can find in Article 32. And I want to mention one last thing about Article 32 is that the controller and processor shall take steps to ensure that any natural person acting under their authority who has access to the personal data doesn't process them except on instructions from the controller. And that's maybe not the first thing you think about when you think about security, but that's something that often goes wrong. In particular, if data of famous people are being processed. There have been examples of people being hospitalized, and then all kinds of people from the hospital, famous people being hospitalized, all kinds of people from the hospital looking into the data. So you have to have a procedure that prevents this kind of processing by people who do not have the authority to process. The other two things, and I think I'm running a bit out of time, so I will not take too much longer of you, but I want to discuss them. The first is the privacy impact assessment. If you process data, in particular when you use new technologies, or if there's a high risk, if you, for instance, monitor people or process lots of special categories of data like health data, it's necessary to conduct a data protection impact assessment. And that the reason for it is that these kind of processing activities are likely to result in a high risk to the rights and freedoms of natural persons. So you have to think about how can you design your data processing activities in a way that you mitigate the eventual risk that follow from processing these data. The assessment that you can find in Article 35, subsection 7. The assessment shall contain at least a systematic description of the processing operations and the purpose of the processing. So that's something you always have to do, of course, have an overview of what you're processing in your organization, etc. Here you have to make it very specific. And this is a very interesting point also, it's under B, an assessment of the necessity and the proportionality of the processing operation in relation to the purposes. So you have a purpose, for instance, you want to monitor whether students are performing well, and if you then monitor every click they do on the online educational environment, every click and at what time they do it, etc., then it's probably not proportional, or I also think not necessary. So that's something you have to think about. You have to think about whether your processing activities are necessary, so you define the purpose, why you want to process, whether they're necessary, and whether they are proportional. So this is an important part of the GDPR also. And I advise always people, even if they are not legally are obliged to do this privacy impact assessment, start by doing some sort of privacy impact assessment light before starting processing activities. And I will come back to it also briefly in discussing privacy by design. But before doing that, I will share some very funny thing with you, or sort of funny. There's Article 36. So imagine you did this privacy impact assessment and you identified some risk related to the data processing, and then you have to mitigate those risks. That's what the privacy impact assessment is for. And then Article 36 is about prior consultation, that you can consult the authority, and you should consult the authority if the processing would result in a high risk in the absence of measures taken by the controller to mitigate the risk. And the English text isn't as absurd as the Dutch text, because the Dutch text says, if you identify the highest risk and you do not take measures. So imagine you go to the supervising authority and say, well, I have this processing activity and there are high risk involved, but I don't take any measures. What should I do? That, of course, doesn't make sense. But even in the more subtle way as it is defined in the English text, most people think it doesn't make much sense, this article, because whoever would go to authority saying, well, I identify those risks, but I'm not able to mitigate it. There are examples. One might be, I'm not sure, but might be blacklists. So if you have lists of people that you don't want to allow to your conference because they always miss their planes, or that you don't want to allow to your shop because they're always lifting, for instance, shoplifting. There are high risks involved there. So you can imagine that under these circumstances, it might be difficult to mitigate those risks, so that you then prior consult the data protection authority. But there are some people that say that this article might be a dead letter. And to conclude this presentation, because I think I've already taken too much time, I want to say a little bit about two other interesting concepts that are new as such. They already were existing, but in the GDPR, that's data, as they call it, data protection by design and by default, which is basically privacy by design. And in particular, the one by design is, I think, very important, because what used to happen a lot in the past is that people were developing systems for processing personal data, and then after developing like for 9 months or so, then on Wednesday they went to the lawyers and said, well, can you check whether it's compliant before Friday, because then we're going to launch. And that, of course, doesn't make sense. You can't, if something is already totally developed, in 2 days' time, check whether something is compliant with the law. So you have to involve the lawyers at an early stage, and that's what privacy by design is meant for, that you have to involve them in an early stage so that they can work with you on developing a responsible way of processing data. And of course, lawyers are often seen as annoying people. And the most extreme example I ever heard was from the GitHub lawyer, who at his first board meeting was interrupting or whatever. He was saying, well, I'm sure you don't want to hear this from a lawyer. And then someone else from the board said, then shut the fuck up. So that's a bit how sometimes people consider lawyers. But I think it's wrong, because we really try to care about the people and the organizations. And in the end, if you comply with those norms, you will feel better, I think, in a way, whatever. But the basic thing I wanna share with you is that it's good to think about these things and to talk with lawyers about them, and just as a joint team, you will get the best results. And then the last thing I want to refer to, that I think so that's also called data protection by default, which I think as a term doesn't make any sense, but it has to do with the 1984 operation of the drafters of the act, because it has to do with privacy by default. So the idea, Facebook for some time had all their options were sharing with the whole world. Well, that's not privacy by default. Privacy by default is that some options, in particular the more confidential ones, aren't shared with the whole world by default. By the way, you might know that there's a lot of interest about privacy these days by Google and Facebook, that there are really concerns. They say, maybe they have to a certain extent. What I find very funny is the fact that Zuckerberg cares so much about his privacy that he seemed to have bought all the houses around his own house, so that he has real privacy for himself. But well, basically, so the concept in the GDPR is called data protection by design, but what it basically boils down to is that you should take measures to ensure that by default only personal data which are necessary for a specific purpose of processing are being processed. So that's, yeah, basically, I think I'm taking quite some time. So I thank you very much for listening to me. I hope it was a bit doable via the distance. And well, thank you very much. And I'm glad to join the I call it the discussion now. I will stop recording. Hey.